They should be able to get treatment so they can kind of figure out what's right and wrong.
I mean, they should be held accountable in the court of law, which was the first part of the question, correct? But but definitely they need to receive treatment as well.
I think exceptions should be made.
I definitely think that there should be exceptions. I think that they should be put in a facility that will treat them while also making sure that they understand that what they did was wrong.
The extent to which they are sentenced or punished might vary with their severity of mental disability, but I think in every case people should answer for their actions.
It should be recognized that there is an issue to be dealt with.
I do not believe any mentally ill person should be able to represent themselves in court.
The mentally ill may or may not understand their capacity, and I think there should be lawyers and professional representation for the mentally ill once they've been designated as mentally ill.
I don't think it's right for us to hold them accountable if they don't really understand what's going on.
It's a lot like trying a juvenile as an adult when you try a mentally ill person as someone who is in full capacity of knowing right from wrong.
In 1992, Scott Panetti murdered his mother-in-law and father-in-law. He then held his wife and daughter hostage overnight until surrendering to the police the next morning. 3 years later, Panetti was tried and convicted of murder. The case seemed straightforward. But Panetti had a history of mental illness, a record of schizophrenia that dated back to 15 years before the homicides. Although this information was apparent, Panetti was found competent to be tried in a court of law for his actions. Panetti then chose to represent himself. During his trial, Panetti dressed as a cowboy and called a number of fictional or deceased characters to the stand as witnesses. Despite these obvious signs of mental illness and incompetence, Scott Panetti was still convicted of capital murder and sentenced to death. Controversial cases like Panetti's raise important questions. Should the mentally ill be held accountable for their actions in a court of law, or should they receive treatment? How do you define mentally ill? What procedures are in place to ensure that people like Scott Panetti don't slip through the cracks? To better understand these questions, let's take a look at the history of mental illness in the United States.
Awareness to the plight of the mentally ill began to rise in the early 1800s when activist Dorothea Dix swept across the nation advocating for reforms to be made to the healthcare system to incorporate the mentally ill. Dix had observed the harsh treatment of the mentally ill in detention centers and asylums, where patients were sent not to be treated, but to be stored and kept out of sight. Dix established 32 state hospitals over the next 40 years. Despite these enormous efforts, mistreatment of the mentally ill continued through the rest of the 19th century, and in matters of policy, the mental health issue was set aside. In 1908, Clifford Beers published an influential autobiography, A Mind That Found Itself, detailing his traumatic experiences in a Connecticut state institution. Beers' inside look into the mental health system confirms that society continued to neglect mental health reform. In the early 1900s, the organization Mental Health America raised awareness of the importance of mental health and promoted change in the treatment of the mentally ill. In 1955, the number of hospitalized mentally ill in the United States rose to 560,000. In response to this trend, Congress created and funded the Commission on Mental Illness and Mental Health. The mental health problem was now recognized and taken seriously. During the 1960s, the number of hospitalized mentally ill began to drop until it reached 130,000 in 1980. But the problem of mental illness did not disappear. In the 1980s, an estimated one-third of all homeless people in the United States had a serious mental illness, most commonly schizophrenia. In 1992, American prisons reported that 7.2% of inmates were profoundly mentally ill. Therefore, over 100,000 seriously mentally ill people were jailed, and over 25% of them held without charges in a psychiatric hospital.
According to Jan Buck, an assessment clinician at the Behavioral Health Services Center at Baylor All Saints Medical Center, Mental illness is defined by the Diagnostic and Statistical Manual of Mental Disorders, or the DSM. This manual classifies mental disorders and lists criteria that indicate what symptoms must be present in order to qualify for a particular diagnosis.
But the person has to be sufficiently impaired that they're unable to tell the difference between right and wrong, would be a very simplistic way to state it. So they are unable to independently tell, subjectively tell, that what they're about to do is the wrong thing to do, something that's prohibited by law.
An illness, disease, or condition other than epilepsy, senility, alcoholism, or mental deficiency that substantially impairs a person's thought, perception of reality, emotional process, or judgment, or grossly impairs behavior as demonstrated by recent disturbed behavior.
To defend someone who's insane, you almost certainly need expert testimony because it's beyond the ability of the average layperson to detect, assess, or qualify mental impairment. So we'd have to get psychologists, psychiatrists, some sort of medical professional in to interview and, well, largely interview, but otherwise test the subject to see if they are in fact mentally impaired and then make a report to the judge. If there is an intent requirement in the crime and the person was unable to form that intent because they can't tell the difference between right and wrong, then they haven't committed a crime at all. So there should be no punishment. They cannot be found guilty. And typically that's what happens with the insanity defense. The person is not tried or not convicted because they were unable to exercise the mental judgment required to actually commit the crime.
Defense attorney would have to do is ask the court the judge to sign an order for the person to have a sanity evaluation conducted. And the sanity evaluation is usually conducted by has to be conducted by a disinterested expert to determine whether or not the person was sane at the time.
So if someone truly is insane, then I don't think they should be held accountable for what they've done and should not be convicted. They should be institutionalized instead. Anyone should have the right to refuse a lawyer. It's a bad idea. But only if they can show that they know what they're doing. With regard to the mentally impaired or the mentally ill, maybe if we have some alternative form of punishment beyond incarceration, like institutionalization, then maybe some different process would be appropriate.
There are four main reasons for a person to be incarcerated. The first, and the one that we typically think of, is punishment. In this case, offenders are sentenced so that they will be held accountable for their actions. This might not be the most applicable situation for a mentally ill person, as they might not understand that they broke the law. The second reason for incrimination is rehabilitation, in which an offender is sent to prison to potentially change their ways, so that they won't commit any more crimes when they are released. In the case of the mentally ill, this purpose might be better served by sending them somewhere other than prison, such as to the hospital or to a psychiatrist. The third reason is specific deterrence, in which a specific individual is sent to jail so they won't commit more crimes. This applies to the mentally ill, although being treated with mental rehabilitation may have a better effect than being imprisoned. The fourth and final reason for incrimination is general deterrence. In this case, a criminal is sent to jail so that others will learn from the example. This doesn't really work with the mentally impaired because they won't necessarily have the logical thought process to learn from the punishments of others. Scott Panetti finally claimed insanity after his February 5, 2004 execution date was set. Following that time, he received several evaluations by the Texas State Court. As of today, Panetti's execution has been stayed indefinitely. Although there are many measures currently in place to make sure that the judicial system does not overlook the rights of the mentally ill, Many communication gaps still exist between the medical and legal sides. Not everyone who works from the legal standpoint understands the medical or psychological point of view. It's important that we understand this disconnect and work to bring understanding and balance to this issue.